Welcome to the Immigration Lawyers Podcast, a part of the Immigration Lawyers Toolbox, an education and marketing publication for the immigration law community that includes legal updates, interviews, discussions, education and CLE material, and more. Note that the information here is for general education only and not intended as individual legal advice. The laws change frequently, so you should consult with an attorney about your specific case. For more information, please visit immigrationlawyerstoolbox.com. All right, everyone, thank you so much for joining on this podcast. We're having a really good breakdown right now of the asylum changes or proposed changes and kind of the counter arguments that have been made. We're going to go over with Victoria Neilson or Vicki Neilson. Vicki, can you introduce yourself and your background and then jump into what you wrote about this?
Sure. Thanks for having me, John. I'm a managing attorney with the Defending Vulnerable Populations program at Catholic Legal Immigration Network, which is a bit of a mouthful. Most people know us as Clinic. We submitted a comment that was over 100 pages long for this proposed regulation because, simply put, if this regulation goes into effect the way that it's drafted, it would pretty much eliminate asylum. I mean, it's hard to imagine. It's kind of hard to imagine anything worse.
Well, what are some major changes that have been proposed?
Yeah. I guess I would start by saying, our very first point was that they only gave 30 days for this comment period and in the middle of this COVID pandemic. So even though we wrote 100 pages, truly, I could have written 300 if I'd had 60 days or more, because it's just that complex in what they're doing to unravel asylum as a form of protection. It's hard to even sort of say, well, this is the worst thing because there's so many terrible things. So one element is that it would give judges the ability to not even hold asylum hearings. So basically, a judge would be given the power to pre-termit asylum claims. So they look at the papers that have been submitted, and if they don't think there's a strong enough claim there, then they wouldn't have to hold a hearing at all. And, this is terrible in any situation, but we're especially concerned about the effect that would have on unrepresented people, especially unrepresented people who've been, subjected to the migrant protection protocols or stuck in Mexico, find it extremely difficult to even fill out an I-589, and then to think that a judge could look at, a minimally completed application form and say, well, I just don't see enough here to even make a claim, so I'm not even going to give you your day in court, when it's so common that it's not until someone's actually being questioned that the facts of the case come out. Other aspects of this rule, I mean, basically it seems like since changes that have gone into effect over the last 3 years, I think advocates have found creative ways to get around, matter of AB, matter of LEA, and this rule kind of looks at every winning argument in an asylum application from the past several years and kind of strikes it down. So, for example, in cases based on domestic violence, after matter of AB, advocates have made different kinds of arguments. We've argued that the claim can be presented as a political opinion claim, saying, basically this woman who's being abused has a feminist political opinion because she believes that women should be treated equally as men, or at least shouldn't be harmed based on their gender. And this regulation would knock out that kind of argument in two ways. One, it defines political opinion in sort of the narrowest possible way, where even being a political activist wouldn't qualify unless the person is sort of aligned with this particular political party, or unless they're trying to change the political party that's in power. It's a very, very narrow view of what political opinion means. And it also has a broad category under Nexus that says basically you can't have a claim that's based on gender. So again, that so many different kinds of claims, including domestic violence, but not limited to that, would just be, knocked out with that one word in this regulation that says, they're based on nexus, there can be no asylum for the following reasons. And one of those reasons is just this one word, gender, with really no explanation of why they're doing that or why gender couldn't be the reason that somebody is facing harm.
That's interesting. I'm surprised they're going so wide, and also by changing the definition of political opinion, it not only affects gender, but it'll consume huge swaths of the political spectrum. So they're aiming for one thing probably, but they're also getting a lot more with it.
Yeah, and it's not. But wait, there's more. There's even more bad stuff. So one thing, the concept of persecution, which is sort of a legal term of art, has never been defined in the statute or the regulations before. And that's also defined in a very narrow way, where it uses the word, severe multiple times in a single sentence, severe harm. It doesn't require adjudicators to look at cumulative harm. And, in many cases, it's not that there's been one incident where somebody almost died, but it's been, the cumulative harm of being beaten or threatened numerous times over, the course of a lifetime or over the course of many months. And that would no longer qualify under the rules as they're written. There are, I'm just trying to think of another really broad area, which is sort of their kitchen sink part of the regulation, is under discretion, where they just kind of put a lot of the anti-asylum measures that they've already put into effect and that are being challenged in court in other contexts. They just sort of throw in and say that adjudicators shall generally deny, as a matter of discretion, asylum cases if somebody entered between ports of entry, asylum cases if somebody traveled through a third country and didn't apply for asylum in that third country. So with that particular one, even though there's a separate regulation that says that, and that separate regulation has now been vacated by a DC district judge, this is kind of a backdoor way to get that in the rules again. Now, it's just discretion, right? It's not a mandatory bar, but it's something that adjudicators shall consider. It's crazy stuff under the discretion, including that if somebody spent 14 days in a country en route to the United States, that in and of itself should generally be a reason to deny asylum. And of course, the rule makes no mention of the fact that it's U.S. government policy, with sort of hearing at the border and not letting people present themselves, that generally is the reason that people are spending more than 2 weeks in Mexico on the way here. They also have this long section about asylum seekers would have to prove that they've filed income taxes in order to not have a negative discretionary denial, which again is, at the same time that new regulations are going into effect that make it that will make many asylum seekers ineligible for work authorization. So they're sort of putting people in a situation where they can't work lawfully yet, and therefore can't get social security numbers, yet they won't be able to succeed with an asylum case unless they can prove that they've filed for for their income taxes.
This is a new tactic. One is the discretion. They updated the policy manual with USCIS out of nowhere to bring that up. So I'm like, okay, discretion is how they're going to go after it. And then, like with the I-944 Declaration of Self-Sufficiency, I have a case I'm working on right now that as we're speaking, it's open on my computer. And they put you in this untenable position where they ask for something that you can't get, and if you can't get it, it could lead to a rejection or denial.
Whether it's like for health insurance, you have to like have a card that says the expiration date of health insurance when those are open-ended. It's just monthly. You pay every month, you get it. It doesn't make much sense. The tax transcripts, the IRS tax transfer website is not even working. Just filing taxes. Who has the sophistication to get an ITIN and not? Very rarely do people understand how to do that. I don't even know how to go about doing that. So they're really just forcing a denial or issues because they're handicapping you in the first place, making it impossible.
Yeah, I mean, I think that's completely true. And I mean, with a lot of these rules and decisions, if you just read one of them and just read the words on the page, like on their face, some of them sound reasonable or normal, but when you start to pile them all up together, you just reach this point where it's like, oh, wait, no, there's actually no way that this person could ever get legal status, because there's so many areas where you're, damned if you do and damned if you don't. And certainly, so again, on the asylum regulation, so under discretion, if somebody enters between ports of entry, if they EWI, they're denied, they can be denied asylum as a matter of discretion. But if they stay in the, if it takes them more than 14 days to get into the United States, they'll be denied asylum as a matter of discretion. Or if they enter using fraudulent documents, they'll be denied as a matter of discretion. So it's sort of like, here's a huge wall, you can't get in, and we're going to deny you for not being able to get in.
Essentially, as you said, it's going to wipe out most of asylum, unless they came with a tourist visa or on a student visa, which is a small number of this.
Right, and then there's even, more rules that would affect people who aren't even necessarily sort of at the southern border, which, I mean, clearly a lot of the animus is directed toward people who are trying to seek asylum at the southern border, but anyone who's been physically in the United States unlawfully for more than a year would be barred from asylum, which seems to be in direct contravention of the INA, which has statutory exceptions to the 1-year filing deadline for asylum. And it's hard to list everything because there's just so much.
But I mean, obviously, if they do any of these, there's going to be lawsuits piling on. Now, the president has been able to get a lot of his people on the federal bench. He's been very successful at that. So we're going to see which presidents get it. But an interesting thing with the immigration is you never know which way a federal judge is necessarily going to go on this stuff. Just the last couple of Supreme Court decisions were kind of surprising, the tone that was taken. So who knows? But definitely this is going to be a lawsuit situation if and when it comes through, because it's just too overbearing. It's just ridiculous.
Yeah. And I mean, one thing with these proposed rules throughout, they say, that each section is severable, so that if anything should be found unlawful, everything else is still lawful, right? So, I think they're obviously anticipating that there's going to be litigation, and that they want to keep as much of the rule as they can while the litigation is happening. But it is, a lot of people are going to suffer in the meanwhile unless there's sort of an injunction against the whole thing before it takes effect. I think even if we have a different administration in the future, this is a proposed rulemaking that's going through the whole NPRM process. So to get rid of the rules would require another rulemaking, which is, can be a lengthy and involved process.
Yeah, people ask me that. Well, if we change the president, will things change? Not necessarily. Once the bureaucracy gets set in place with regulations, with their own people and their own hiring, it's not that easy to undo this kind of stuff. And maybe piecemeal here or there, we'll fight some it. And I think the lawsuits will be it, but you have to have a really complete complaint in the lawsuit to attack every single prong, and have a judge that's going to review that. These decisions on these are going to be super long decisions to go over all this kind of stuff. So right now you submitted it and you made it within the deadline for submitting a response. It's kind of up to them how long they take after this.
Yeah, I mean, the good news is I think there were about 80,000 comments submitted. So, there was a real push by the advocacy community to get as many comments as possible. Every unique comment that's submitted that's substantive, the agency has to read the comments, and as they before they issue a final rule, they have to address the substantive comments. So, some of the comments were based on a clinic click to comment, just a button, which it's just, I oppose this rule because it's wrong kind of thing. But there were, I think, a lot of more substantive comments. There's just so much wrong with this rule. But I mean, going back to my first point, that it's really insane that they only gave 30 days for this complete rewrite of the law. I mean, normally when there's a proposed regulation, there'll be sort of 50 pages of introductory material and then, 2 pages of actual regulations that are going to be changed. And in this, there were 60 pages of regulations that were, but you have to actually read kind of word for word. And for some of them, each word is a loaded legal term. So for many organizations ended up having to just focus on sort of 1 or 2 of the, 40 or more really substantial changes that this regulation was putting into effect. So I don't know, maybe there'll be some way to
this level of change, and really is something Congress has to get involved with them. This is really kind of gets into INA and potentially, I haven't read it, but it seems so widespread that it's going to eventually hit something in INA that goes counteracts. As you mentioned, it kind of goes counter to 1 year filing deadline and stuff. So on its face, they may have, they have the severability part, but on its face, they may have overdone it by going so broad.
Yeah, I mean, I certainly think that there are some aspects of the regulations that just clearly contradict what's in the INA, like sort of what I started with, pre-termitting asylum claims and not even letting people have a day in court. I mean, there is in the INA language that the respondent is allowed to present evidence and the judge is supposed to take testimony. I guess you could blame on the footsteps of Congress as well, because a lot of the asylum law is, the INA is the skeleton and the regulations put the flesh on the bones. And there's some areas where other administrations could have issued regulations, for example, defining persecution, defining particular social group, and those regulations had not been, issued up or published up until this point. I mean, there actually was a proposed rule on particular social group. I can't remember, more than 10 years ago, which was, proposed, and there were comments, and then it just never got published. So this administration has, stepped into that void and done everything they can through the regulatory process to eliminate asylum. And, from day one, the administration has been calling asylum, a loophole, and called asylum seekers fraudsters. And it's just really sad if you work with asylum seekers and see the sort of horrible things that people are fleeing, that they're up against this level of difficulty in proving their cases when people give up everything to try to get safety here. And it's really awful.
But, with the election year coming and the chances of the administration changing, they're probably going to go all out and do whatever they can before it's done. So it's probably not the end of what we're seeing, not just asylum, but also other proclamations and orders that they're going to put through.
Yeah, no, I think that's certainly true. And, I'm working now on comments for another sort of end to asylum regulation where comments are due on August 10th, where basically they put out a proposed rule saying that having a communicable disease, including COVID, or traveling through a country where COVID is prevalent, or displaying potential symptoms of COVID, or possibly having come into contact with somebody who might have had COVID, makes someone ineligible for asylum or withholding of removal or withholding under CAT because of security reasons, because they threaten the security of the United States. I mean, it's another thing where it's I mean, it's sort of laughably broad, but if it doesn't get enjoined, if somebody shows up at an asylum hearing in immigration court and is coughing, the judge could decide that they might have COVID and therefore there's security risk and are barred from even seeking asylum, which is, you know.
Yeah, if they're detained, obviously people in the detain center are going to have it, so automatically they put them in that position.
Right.
Yeah, I was going to say just this proposed rulemaking, all this kind of stuff is insane. And one thing that they did is I used to get notification of these proposed rule changes, I think through USCIS, but they stopped that a week or two ago. And so you have to go separately to sign up for getting through the other website that the government has. And it's like, it took me like a little bit to figure out how to sign up for the new updates and stuff. But if you have stopped getting these updates when they're doing these proposed rule changes from DHS or USCIS, that's the reason. Definitely sign up. I wish I remember what website I went to, but I have to go click a bunch of stuff to get these new updates when these things come out. And they make it so hard to figure out how to get it or read it. It's like, it's really cumbersome, but it's really important to keep an eye out on this stuff because that's how they're getting it in now.
Yeah, no. And I mean, we've seen, you know, with the Supreme Court's DACA decision, I mean, it really does matter that the administration has to follow the right procedures in order to implement changes. So it's really important for all of us to put in comments on any injustice that we see, which there are many at the moment. So, and it does, they have to respond to them. And then if there is litigation, we're helping to build a record to show why there was no foundation for this rule change. So it's important to keep working on these comments.
Definitely. Vicky, thank you so much for coming and discussing this stuff. I know people are overwhelmed or just with everything, so I don't have time to read this. So I really wanted to have you on board to kind of fill people in on how much of a travesty it is and how overbearing it is. If people wanted to contact you, what's the best way for them to reach out? Social media or email or anything like that?
Sure. You could email me at vneilson, that's VNEILSON at cliniclegal.org.
Great. Vicky, thank you so much for coming on the show. Hope we talk again.
Yeah, great. Thank you.
You're welcome. Bye-bye.
Bye.
Thank you for listening to this episode. For previous episodes and more, please visit the podcast page of our website, immigrationlawyerstoolbox.com. You can also visit the Toolbox YouTube and LinkedIn pages to catch the video versions of these podcasts, news updates, and a lot more. Immigration lawyers can also contact me to join the private Facebook page. The email is info@immigrationlawyerstoolbox.com.